Welcome back to a weekly webinar series. Today we're discussing a very important development in the judicial pronouncements. Over to Anil.
Thank you, Ankit. Welcome to 134th episode of AAA Weekly Webinar Series. I hope everyone has celebrated Diwali to its best. And I'm sure this is what I witnessed, that I couldn't hear much of noise of crackers. And the pollution is also not that high as we have seen in the past. So thank you everyone, all the citizens, for keeping this in control. So today we are discussing the implication of Section 32 capital A of IBC, and that is the that is something which is the triggered because of two judgments of Judicial. One is from Bombay High Court and the other is from NCLAT, New Delhi, from the principal bench. So these two judgments have in fact clarified the applicability of Section 32 capital A on, and it actually will have impact on a lot of cases, and to my understanding, a lot of cases where the assets are attached by enforcement agencies, that may be Enforcement Directorate or even CBI or even any other agency. So wherever some criminal proceedings are continuing against the company as well as against the promoters. So these judgments clarifying the applicability of Section 32 capital A would help in fact many cases. Although there are a couple of other judgments which are still pending before Honorable Supreme Court, but I think the time has come now when the Honorable Supreme Court also will decide in this favor, and I would see that this is the time that all the liquidators or all the resolution professionals should start taking the action and start realizing the assets of the corporate debtors. Now, we will discuss first what exactly Section 32 capital A of the IBC is and what kind of immunity it provides to the corporate debtor, whether that immunity is extended to the suspended management or ex-directors of the company or not, and how it assures fresh start to the resolution applicant. So basically the core concept when this section in fact was introduced, when we need to read what this section is all about. Now, 32 capital A, it reads like, and I have in fact kind of divided into the various implications, notwithstanding anything to the contrary contained in this code or any other law for the time being in force. So this actually is a non-obstante clause, which actually provides the supremacy of this clause 32 capital A over IBC and even other laws. The liability of the corporate debtor. One, that it is only and only talking about the liability of the corporate debtor. It is not talking about the liability of the promoters or directors or suspended management or even the officers of the company. It is not talking about liability of the corporate debtor for an offense committed prior to the commencement of CIRP. All kind of offenses. When we talk about offense means all those kind of provisions in any law where the corporate debtor or the directors can be prosecuted. So this talks about all offenses. So this offenses committed prior to the commencement of CIRP, it is applicable to only and only on those offenses. If any particular offense is committed during CIRP, it is not applicable. Or even after the CIRP, it is not applicable. Shall cease. Basically, what is talking about the liability of the corporate debtor shall cease. Shall means it is actually very, very clear that it shall cease. and the corporate debtor shall not be prosecuted for such an offense. One, that the liability of the corporate debtor shall cease. Other, and the corporate debtor shall not be prosecuted for such an offense from the date the resolution plan has been approved by the adjudicating authority under section 31. If the resolution plan results in the change in the management or control of the corporate debtor to a person. So this is very clear that from the date of the approval of the resolution plan, the liability of the corporate debtor will cease, and the corporate debtor shall not be prosecuted for such an offense. So this is where even the prosecution also cannot begin, and if the prosecution or anything has already started, that actually shall cease from the date of approval of the resolution plan, provided that there is a change in the management or control of the corporate debtor to a person who was not a promoter, or in the management or control of the corporate debtor or a related party to such a person, or a person with regard to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offense, and has submitted or filed a report or a complaint to the relevant statutory authority of the court. So what we are trying to say, that in section 32 capital A subsection 1, the liability of the corporate debtor shall cease. If the liability has already been identified, it shall cease, and the corporate debtor shall not be prosecuted for such offense. Offense has actually been committed prior to the commencement of CIRP, that shall cease. The liability shall cease, and the prosecution shall not even start from the date of the approval of the resolution plan. So that means that the approval of the resolution plan is very important. In case there is no approval of the resolution plan, section 32 capital A subsection 1 may not be applicable. And also, if the resolution plan has actually been given to, and in case the resolution plan has actually been received from the promoters or in the management, any person who was in the management or a promoter, so then in that case, that resolution plan also will not provide this immunity. And also, those people shall not take this company under a resolution process who actually have been involved in the offense which is being proceeded against the corporate debtor. That is something which is very important. Now there are provisos. One proviso says that if a prosecution had been instituted during CIRP against such corporate debtor, it shall stand discharged from the date of approval of the resolution plan, subject to requirements of this subsection having been fulfilled. So that means in case any prosecution has been instituted during CIRP, that is during moratorium, against such corporate debtor, it shall stand discharged from the date of approval of the resolution plan, subject to requirements of this subsection having been fulfilled. The only thing that we have to say, that the resolution should approve, resolution plan must approve, and if the resolution plan is not approved, section 32 capital A is not applicable. So then where there is a further proviso, which says that every person, in case it is a LLP, in case it's a limited liability partnership, every person who is considered to be a designated partner, or in case it is a company, then officer who is in default. So in the case of LLP, designated partner. In the case of a company, officers who is in default as defined in section 2 subsection 60 of the Companies Act 2013. That those people shall continue to be liable to be prosecuted and punished for such an offense committed by the corporate debtor, notwithstanding that the corporate debtor's liability has ceased under this subsection. So the liability of the corporate debtor has been seized because of 32 capital A, because the resolution plan has been approved. Second, any prosecution, the corporate debtor, it will not be prosecuted for any offense committed prior to CIRP. So the first paragraph says that the resolution plan should have been approved. Even the proviso says that the resolution plan may have been approved, but even if during CIRP the prosecution has been instituted, section 14 is not applicable. What is applicable is 32A. In section 32A, it is very clear that if a resolution plan is approved, that it shall stand discharged. The prosecution shall stand discharged. Now, coming to subsection 2 of section 32 capital A, which is also very important. No, this was about the liability of the corporate debtor. The first subsection is about liability of the corporate debtor, which shall cease. It is also the prosecution. It is also the corporate debtor shall not be prosecuted. So one, if the liability is already occurred, it shall cease. In case it has not occurred, the corporate debtor shall not be prosecuted for such an offense. This is what subsection says. Subsection 1 says, and also it says that the partners and the promoters are not exempted. They shall continue to be liable. And it also says that even if the prosecution is instituted during CIRP, then again it shall get discharged only if a resolution plan is approved as per this subsection, and all the requirements has to be fulfilled. What are the requirements? That the resolution plan has not been submitted by the promoters or the directors or any related party or any other person who is involved in the offense, and its name appears in the report submitted by the investigating agency. This is what the first section says. Now let us say section 2. Subsection 2 says that no action shall be taken against the property of the corporate debtor. No action shall be taken against the property of the corporate debtor in relation to an offense committed prior to commencement of CIRP of the corporate debtor, where such property is covered under a resolution plan approved by the adjudicating authority under section 31, which results in the change in the control of the corporate debtor to a person. Again, the same conditions, like it must be changed as per the requirement in this particular section. Now the question is very important: or sale of liquidation assets, or sale of liquidation assets under the provisions of chapter 3 and of part 2 of the code to a person who was. Now the one that the no action shall be taken against the property of the corporate debtor, which results in the change in control of the corporate debtor to a person, or sale of the assets. The only condition is who was not the promoter and the person in control, and that condition is the same. Now comes the explanation for the purpose of this subsection. Now the explanation says, see, when we actually come to subsection 2, the very first word is no action. The very first word is no action. So this particular proviso actually discuss this explanation. Now the explanation is just discussing what exactly the action means. Now, an action against the property of the corporate debtor in relation to an offense shall include attachment, seizure, retention, or confiscation of such property under such law as may be applicable to the corporate debtor. As may be applicable to the corporate debtor. So subsection 2 says no action, and this particular explanation says that the action against the property of the corporate debtor in relation to offense shall include. It is an inclusive definition. Shall include the attachment, seizure, retention, and confiscation of the assets. Again, it says that nothing in this subsection shall be construed to bar an action against the property of any person. Again, any person other than the corporate debtor, or a person who has acquired such property through CIRP or liquidation process under this code and fulfills the requirements specified in this section, against whom such an action may be taken under such law as may be applicable. So this actually makes it clear that subsection 2 is applicable to the sale of liquidation assets also. 3, that nothing in this subsection shall be constituted to be a bar on action taken against the property of any person, however, other than the person who has taken the assets as per a resolution plan or under liquidation. So therefore, section 32 capital A is applicable to all those cases where the resolution plan has been approved and the liquidation assets have been sold. But the resolution, the corporate debtor under a resolution plan or any asset of the corporate debtor must not have gone to a promoter or in the management or a control of the corporate debtor or a related party or a person who is accused as per the report of the investigating authority. Now, when we say the officers who is in default, they would continue to be responsible. They would continue to be prosecuted. The officers in default is defined in section 2, subsection 60 of the Companies Act, and it says whole-time director. It says key managerial personals like the CEOs and MD and the chief financial officer and the company secretary and the other designated as KMP under the Act. Person in accordance with whose directions or instructions the board of directors are accustomed to act. Any person charged with the responsibility to comply with provisions, directors, in case no specific key managerial personnel or other officer has been designated, the entire board of directors may be held collectively responsible. Any person who authorizes, actively participates, or neglects to take action against the default, share transfer agent, registrars, merchant bankers, they can all also, in case they are also involved in the process. Now let us see what actually and how we can interpret. One, the first condition which is important, the resolution plan must be approved by the adjudicating authority under section 31. Two, that the asset must have been sold under the liquidation process, and the plan must result, or the asset sale must result in the change of management and control of the corporate debtor. Three conditions: the new management or the new control must not be given to the promoter, previous management member, a related party to them, any person involved in the abetting or conspiring of the in the offense. Now, when we talk about the first proviso to subsection 1, it says that the resolution plan has to be approved under section 31 and the prosecution has been started during CIRP, then the corporate debtor is discharged from the prosecution. Conditions, again the same, the new management conditions. And then we talk about second proviso. Second proviso talks about that it is the some of the individuals associated with the corporate debtor, like the responsible officers, directors, promoters, they would continue to be liable for the offenses. When we talk about subsection 2, it actually talks about the bar against the corporate debtor's property in connection with the offenses, and the conditions are the same. One, that it is approval of the resolution plan or sale of the liquidation assets. Then now I think we need to see the judicial pronouncements, and I will come to those two judgments which are very, very important, very recent judgments clarifying the interpretation of section 32 capital A of the IBC. But the first judgment that we actually have to refer is judgment in the name of Manish Kumar versus Union of India. This judgment is from Honorable Supreme Court. It is dated 19th of January 2021. It only talks about the constitutional validity of section 32 capital A. And the Honorable Supreme Court held that the 32A is constitutionally valid, affirming that it aligns with the IBC objective to maximize asset value and ensure smooth transfer to new management without legacy liabilities. It rejected the arguments that section 32 capital A was arbitrary or violated the articles 14 of the Constitution, emphasizing that the immunity under section 32A serves a legitimate economic purpose. Now, the Supreme Court, in fact, upheld this constitutional validity. Then comes the judgment from the Bombay High Court, and that judgment is in the name of Mr. Shiv Charan and others. versus adjudicating authority under PMLA. Adjudicating authority under PMLA, the applicants in this case was one Mr. Shiv Charan, with then one Miss Pushpavalata Bai, and then Miss Bharti Agarwal. They are all the resolution applicants for. They are all the resolution applicants for a company called DSK Southern Projects Private Limited, and the respondent in this case was adjudicating authority under PMLA and the deputy director of enforcement directorate. Now the prayers in this case from the resolution applicants. These prayers were from the resolution applicant. One, then the quashing of the ECIR, which is an original document and attachment orders issued by enforcement directorate concerning the corporate debtor. And the other prayer was the direction to release attached properties as per NCLT order under section 32A. So first the NCLT issued an order. NCLT issued an order that 32A is applicable and the resolution plan has been approved, and we have seen that this resolution plan has not been submitted by any of the promoter or their related party or any of the person who actually been named in the charge sheet or report submitted by the investigating authority. Therefore, this resolution plan is approved and section 32A immunity is available to this. However, the enforcement directorate did not release the assets. Therefore, the resolution applicants went to the High Court of Bombay. And in this particular case, the basic facts are that in 2017, FIR was filed against the corporate debtor, which is DSK Southern Projects Private Limited, for alleged offences of cheating and criminal breach of trust. In February 19, ED issued a provisional attachment order under Section 5 of the PMLA, and that was confirmed on 5th August 2019 under Section 8 by the adjudicating authority. In 21, that means 4 years after the FIR or ECIR, and then 2 years after the attachment, CIRP started. In 2023, NCLT approved a resolution plan and directed or ordered ED, Enforcement Directorate, to release the attached properties under Section 32 capital A. On 28th of April 2023, NCLT reiterated its direction for ED to release attached properties after approving the resolution plan. Now, the arguments from the applicants are resolution applicant. What they are saying before Honorable High Court, that 32 capital A provides immunity from prosecution and attachment of assets. And they also argued that NCLT has ordered directing the release of the properties, and they have the jurisdiction to do this under Section 60, subsection 5 of the IBC. Then also they asserted that the ED should release the attached assets. Now the respondents, the Enforcement Directorate, said that the ED contended that the attachment under PMLA are aimed at recovering proceeds of crime, and these actions fall outside the purview of IBC. Again, Enforcement Directorate argued that Section 32A shall not negate the purpose of the PMLA, and NCLT lacks authority to interfere with attachment under PMLA. Then the ED also argued that any immunity claimed under IBC should not conflict with the PMLA objectives. Now, this is something where Section 32A, 60, subsection 5, or all this was used, and even the Manish Kumar versus Union of India was also used, and even the Rajiv Chakravarti versus Enforcement Directorate, that's a judgment of Delhi High Court, that was also used, and the Axis Bank versus Enforcement Directorate, which is pending before Honorable Supreme Court, was also used. In this case, finally the High Court, Bombay High Court, held that Section 32A is a non-obstante clause granting immunity once a resolution plan is approved, rendering further prosecution against corporate debtor asserts ineffective. Then it says the NCLT is within its jurisdiction under Section 60, subsection 5 of the IBC to address questions relating to the resolution proceedings, including the effect of ED. The court clarified that immunity under Section 32 capital A applies if there is a complete change in management and control Disassociating prior offenders from the corporate debtor, the court reinforced that ED attachment should be lifted automatically upon resolution plan approval to align with the purpose of the IBC. So this was the judgment from Bombay High Court, and in fact, again, the most important part is that on 13th of August 2024, a similar judgment was received from Principal Bench of Anklet, New Delhi, that is in the name of Vantage Point Assets Pte Limited. Vantage Point Assets Pte Limited versus Gaurav Mishra, the resolution professional of Alchemist Infra Realty Limited. Alchemist Infra Realty Limited. So this judgment is dated 13th of August 2024, very recently, from Principal Bench, New Delhi, and the applicant was again a successful resolution applicant. Applicant was a successful resolution applicant, Vantage Point Asset Pte Limited, that means maybe a Singapore-based company, and the Gaurav Mishra is the resolution professional. Now the prayers from the applicant was: one, setting aside of paragraph 60 of NCLT's impugned order, which denied the protection under section 32 capital A of the IBC for lifting attachment made by the Enforcement Directorate. Because in this particular case, NCLT denied the protection under section 32A, denied, and NCLAT reversed this judgment of NCLT. And then another prayer from the applicant was an order for release of properties and accounts attached by central and state agencies, including Enforcement Directorate, to facilitate the implementation of the approved resolution plan. This was another prayer. Now, in this case, if you see the facts of the case, in October 21, CIRP started. In October 23, the Committee of Creditors approved the resolution plan submitted by Vantage Point Asset Pte, and a letter of intent was issued to the applicant. In July 24, NCLT New Delhi bench approved the resolution plan but denied the applicant's request for a release of assets attached by the ED. That particular one, immunity was not granted to SRA, and it was said that you have to go through the PMLA court to get these assets detached. Now the applicant, like these were the argument, and the basis was also Shiv Charan judgment of Bombay High Court, and the respondents, like again the represented by senior counsels, in fact supported the arguments concept. Now the legal issues are again whether 32A entitles successful resolution applicant to the immunity. Number two, section and the law under which the judgment is passed, that is section 32A 14(1), the moratorium was also discussed. Section 5 of the PML was also discussed, and the Rajiv Chakravarti versus Director of Enforcement from Delhi High Court, that was differentiated, because that was a judgment of Delhi High Court which said that the moratorium is not applicable to for the criminal cases, for any kind of prosecution. It is not applicable on a moratorium. And finally, the NCLAT principal bench held that the NCLT erred in denying. There was an error by NCLT in denying the prosecution, in denying the protection under section 32A, and it set aside the portion of that NCLT order that refused the release of the attached assets of the ED. Further, NCLAT granted the applicant the relief of having the Enforcement Directorate attachment lifted on the basis of section 32A. This was a great judgment, and now based on this High Court, Bombay High Court judgment in the case of Shiv Charan, the NCLAT judgment in the case of Vantage, and then this Vantage Point asset. Now, I think it is very clear that the resolution plan actually can be sought. The resolution plans can be in fact, invited even if the assets are attached by the enforcement directorate. Similarly, the assets can also be sold under liquidation, and that is something which, after the assets are sold, then we can go back to NCLT that assets have been sold and it has been sold to a person who was not part of the management. So this is where the permission would be granted by NCLT for detachment of the assets. This is exactly that we have the clear cases. So at this stage, Ankit, can we have some questions, and then we can move on to many other kind of judgments that we have for this.
Yeah, so I will take them one by one. So the first question is from Mr. P.D. Rasam. He says whether 32A contains in resolution plan is not as per law. The plan has been submitted by MSME director and asked for 32A, and she must not approve the plan.
Yes, if even if it is MSME, Section 32 capital A is applicable only if the resolution plan only if there is a complete change in the management. If there is no change in the management and the same management or the same promoters or their related parties are coming back to the company after the resolution plan is approved, Section 32A immunity would not be available.
The
Even
MSME,
if it is MSME.
the MSME immunity is not available to 32A.
Yes.
Then we talk about, so there's a question that our RP had classified a third party collateral security holder loan given to associate company as a FC in our CRP, even after pointing out the SC decision Anuj Jain case, where SC clearly says the financial debt and financial credit definition have to be fulfilled, our RP not willing to change. So there can be.
This is not a related question. I think we can take the questions only on Section 32 capital A today.
So other questions are not relating to 32A. We can maybe, if somebody has a question on 32A, maybe they can raise their hands and we can allow them to speak. But please, only 32A. Yes. Mr. Maharaj.
Yes, good afternoon, sir. So, in order to decide a case, like, suppose that any account has been frozen by enforcement agencies, it is not, it specifically talks about ED, it talks about all the enforcement agencies, if I'm not wrong.
All kind of investigating agencies, all kind of enforcement agencies, this 32A is applicable.
Okay. And that what is that latest judgment like we have to rely upon?
No, I think I have said there are two judgments. One is the Vantage Point from NCLAT, New Delhi Principal Bench, and the other is Shiv Charan, that is the Bombay High Court judgment. Both are applicable for applicability of Section 32 capital A.
Thank you, sir. Well said.
Yes.
Yes, if we can have Rakesh ji.
Sir, my question is, in my case, this company is under liquidation.
Yes.
And land of the company is owned by the promoter. Sorry, land is owned by the promoter, and this factory is at the land of promoter only.
Right.
Now, building and plant and machinery belong to the CD.
Right.
The assets of the CD have been freezed by the ED. Now, in this situation, even if I file an application under Section 32A for defreezing of the assets, the plant and machinery can be removed from the site, but building cannot be removed because the land belongs to the promoter. So, in such situation, is there any logic for me to file an application simply for detachment or not?
No, it's the one that the company is under liquidation. Number two,
Yes.
The assets are owned by one asset, which is land and building, is owned by the directors, and the machinery is owned by the corporate debtor. The liquidator is only concerned about the machinery. Liquidator is not concerned about the land and building, because that the banks will sell under SARFAESI Act, not by the liquidator. Next is the in case you sell these plant and machinery in liquidation and you sell it to a person who is not the promoter, then you can actually make an application to NCLT that now the assets have been sold to a person other than the erstwhile management. Now the enforcement directorate should be ordered to release the attachment. That is the application that you can file after you sell the assets. But the law is made in such a manner that it is not something which is possible that somebody can give you a detachment order before even you do that. Even if the detachment order would be given, that kind of detachment order will be subject to a condition that you will not sell it to promoters.
Sir, recently, if my memory is not incorrect, there was judgment by Supreme Court wherein it was mentioned that under section 5(8) or 5(7), application has to be filed with the appropriate authority, that is PMLA court, for detachment of assets. Whether this judgment of Supreme Court was after this Bante's point judgment of Anklet, or
I
Shivcharan
think
judgment of...
you are talking about the Vijay Madan Lal Chaudhary judgment of Supreme Court, where the Supreme Court has said that if there is any kind of claim from any other person and any person want to get some assets detached, that is the power of appellate authority under PMLA and also the special courts under PMLA. That is Vijay Madan Lal Chaudhary versus Union of India. That is what is the application. That is what is the Honorable Supreme Court judgment that you are talking about. So in that judgment, what the Supreme Court clarified that who has the powers to detach the assets of somebody else. If there are some other person's assets have been attached, so these two courts have the power to detach that. But section 32A is in section under IBC. So therefore, any section under IBC, it has to be in the process of CIRP or in liquidation. So that asset must be owned by the corporate debtor. So therefore, what we are talking about today is the section 32 capital A, which is applicable to provide immunity to the assets of the corporate debtor. In your case, assets of the corporate debtor is only plant and machinery and not the land and building, because the land and building is owned by the directors. So therefore, the immunity can be given only to the plant and machinery and not to the other assets.
I have already filed an application in NCLT, and this matter is getting delayed for last 4 years for detachment of assets. And recently, this ED filed an application that there are certain judgments, and therefore we would like to place them on record, and you cannot detach these assets. My SCC advised me to file an application in PMLA court. I am of the view, because SCC advised me to file an application before the PMLA court in view of judgment of Supreme Court. I am a bit confused on this issue. If I continue with
application can be filed before special courts, and we have filed multiple applications, so there are delays in special courts also. Then application can also be filed before the appellate authority under PMLA. So there also there is a delay. But now, based on these two judgments, one is the Shivcharan and the other is the Vantage Point. I think you can take an opinion, you can sell the liquidation assets, and after the sale, then you can go to the NCLT that I have sold the assets to a person who is not the promoter or erstwhile management, and then you give me the order so that the assets are detached. So in case the NCLT does not give the order, then you can go to NCLT and this particular Vantage Point will help you.
Okay, just out of context, Mr. Goel, the issue is plant and machinery and building belongs to the CD, land only belongs to the promoters. But what is happening if I sell the plant and machinery to some third party? That will hardly fetch me, say, around 1 crore rupees or so, just like a scrap value.
So tell me, then land and building is also attached by enforcement directorate or not?
Yes, sir. Yes, sir. It is attached.
That is also attached. So I don't think the land and building you will get ever detachment order. For the
Sir,
land
even if,
and building, the
sir, even if
detachment order will not be given to you. That will
that is
take
right, sir.
time.
That is right, sir. Building, even if is detached, it will not fetch me any value because land belongs to the promoter. So building is useless for me. Plant and machinery I can sell to the third party, but that can be sold only as a scrap. Now my wisdom says that I am earning around 25 lakh rupees by leasing this property, building and plant on to some third party. If I sell it, I will hardly get 25 lakh rupees or 50 lakh rupees. So whether I should wait for detachment by ED and then sell, or I can just sell it for 25 lakh rupees as it is as a scrap.
No, I think in case you can give to somebody on lease, I think that will be a better proposition that the lease money will come to the company and with that you can fight. But I can certainly tell you that the 32A is applicable on the assets owned by the company. It is not
Right,
applicable to assets owned by the other persons. So
right, sir.
therefore, the 32A has given the clarity. So 32A clarity is only and only on the assets owned by the corporate debtor. So the land which is owned by the promoters and the building and the machinery, if collectively can be given to some other person on lease, and the banks can make that kind of money like 25 lakhs, as you said, or even more per year. So that is the only option for the time being, which is the best option.
Thank you so much, sir. Thank you.
Lalinji, maybe you can share your questions.
So you are not audible.
Voice is breaking, Lalinji. Yeah, better now. No, Lalinji, I think that Lalinji, your voice is breaking. You're not audible.
It is not audible so far.
Maybe we can ask Anilji to share his question in the meantime. We also have another question from Mr. Rasam.
Good morning, sir. Happy Diwali to you, sir.
Good morning, Ji. Thank you very much.
Acha,
Thank you.
yes, sir. In my case, though I heard you fully, I understand. Just want two confirmation. After the commencement of liquidation, can ED attach the assets?
So ED is doing all this. ED is attaching the assets even during the CIRP and also during liquidation. However, the only 32A says that in case you are able to sell it to a person other than the promoters, then section 32A immunity will be granted to the buyer. So ED can attach because no moratorium is applicable on criminal activities or offenses. Prosecution can be started at any point of time. The moratorium is not applicable to prosecution or commencement of any prosecution proceedings. So during liquidation or during CIRP, the ED can attach. But if it is CIRP, then you have to get a resolution plan. If it is liquidation, then you have to sell the assets. You have to find a buyer who actually is ready to buy the assets on a part payment, and then the balance payment can be given later after the assets are detached by the NCLT and later on by ED, and then the balance amount can be paid.
But sir, thank you. That I understood. But in the provisional attachment and the order which is confirmed to the PMLA appellate, that PMLA, that liquidator cannot do anything with those assets which are under attachment. It has put restriction for sale also.
Now, I think this 32A, the appellate authority under PMLA has actually put a condition on you, but section 32A, which clearly says that is something in case you have already got an order from PMLA appellate authority, then the immediate action is to save the obligation of a liquidator that you go to High Court, and in High Court you can say that I want a permission to sell so that I can comply with the conditions of section 32 capital A. That is the prayer that you should give it to the High Court, because you have received an order from PMLA appellate authority, so the next appeal lies before High Court. High Court, you should actually give a prayer that I should be permitted to sell the assets under liquidation because 32A is applicable to me.
I agree, sir. We have filed that petition with Delhi, writ petition with Delhi High Court. Just I want to correct, PMLA appellate has not given order yet. I just want to correct myself.
Okay.
PMLA has confirmed the attachment, state putting restriction on any to any do anything with those assets. And I'm in
That
PMLA appellate
that is
also,
that
and
is the
I'm in NCLT also.
Mhm. So NCLT may or may not be able to give any order, but then based on this NCLAT order, NCLT also can give you order. And I think now it is a right time that we should aggressively take up all the litigations, get more and more orders. I will also come up with some more orders, which I will say that even the Delhi High Court also has got some good orders which actually will help you.
Thank you, sir. But NCLT unfortunately has not given me judgment. Has not given me hearing since last 3 years. Rather, it is more than 4.5 years. And
So
PMLA
now
appellate also has taken 4 years.
it happens that in case the NCLT is not giving some hearing, that means the NCLT is not able to find a particular way out. Now, since the NCLAT has given this judgment in the case of Vantage Point, you can place this judgment on record and also make an application for early hearing. That actually will motivate the court to give an order at least based on NCLAT order in the case of Vantage, and also Shiv Charan order in the case of Bombay High Court.
We did that, sir, but we have not quoted these cases. But we filed an early hearing petition. That also got wasted. That principal bench is not ready to hear.
But then you actually have to place these two judgments through an affidavit and also with the early hearing. So then only this will happen. And I tell you, it is now our duty. Somehow everyone is expecting that the RP will act uh, uh, diligently to get an order from the court. Now,
We'll do
if
that,
we,
sir.
in case we tell our creditors, or in case we tell IBBI that the RP has not got any order for the last 4 years, then there is immediately some questions will be asked whether you filed the early hearing, whether you also appraised the court with the latest development, whether you also submitted the some of the latest judgment. So these are the questions which can be asked to you by the creditors as well as by the IBBI.
Early hearing we have filed, but we'll appraise the court NCLT with the latest judgment which you have referred. We'll do that.
With
But
this judgment, we can actually say some senior advocate can vehemently argue that now this is the time that you have a way forward. Milord, you can actually give me a judgment, or even you can deny me, and
but
that can be.
but certainly I cannot sell as of now.
So since you have that kind of order from the PMLA appellate
Yeah.
authority, I will not advise you to do a kind of contempt of the court. I will
Yeah.
not.
Thank you, sir. Thank you. Obliged.
Yes. Thank you.
So I will take some quick questions. One question that is coming in is that can an MSME or a successful SRA, claim similar relief to 32A without mentioning 32A? And will that solve any purpose per se?
See, like what we are talking about is the MSME and the prosecution and the all the attachment of assets by Enforcement Directorate. Now, attachment of assets by Enforcement Directorate, there is no relief under MSME Act, but that relief is only under IBC. So what we are saying is that if there is any relief under MSME, in fact, in case you see that there was another judgment which we discussed in the earlier webinars, that a person, in fact, he wanted to take the benefit of MSME judgment, and he says that yes, we are MSME. So that was said that is not the objective of the MSME, that somebody is trying to use the MSME provisions even to avoid insolvency. That was in fact rejected. So therefore, MSME is only to give a comfort to MSME and not to protect them from all these offenses.
So
However,
MSME CD, MSME SRA can claim this only if the management is changing. That will be available to everyone then.
it is not the question of MSME SRA.
Can be
Only
any
the
SRA.
MSME CD. The
Yeah.
entire section 240 capital A is applicable to MSME CD, not to MSME RA.
Yes, understood. Then we have a question that is there any provision against which 32A protection is not available? Any scenario, any provision
Yes,
where
there
you
is only
feel
one scenario that the resolution plan must have been approved by the adjudicating authority, or the sale must have been done by the liquidator. And in both these scenarios, the asset or the corporate debtor must not have gone to the earlier promoters or their related parties or any person whose name is mentioned in the charge sheet as accused. So therefore, in case these are the conditions, in case any of these conditions are not fulfilled, then the immunity under section 32 capital A is not available.
right? Then we have Ravi. So that's a different question. It is about willful defaulters. But then I think what we can do is we can take up another question from Mr. PD Rasam, because he had raised his hand. If you want to speak out your question, sir. Otherwise, we'll.
Yes, sir. You have replied that in case of MSME, 32A is not applicable. But in case the resolution plan has been passed, now one of the bank has challenged that because in the resolution plan 32A has been mentioned, so resolution plans must not be uh, approved by the NCLAT. Can anyone take that stand? Because in the plan it is mentioned.
No, in the plan, the bank has
So
already.
I think the facts are the 32A is mentioned in the plan, and the plan is submitted by the promoters. So now
Yes.
that's the difficulty. So here in this case, the only process that can be adopted is to kind of give a clarification to NCLT that 32A provisions need not be approved because they may not be available to the MSME promoters.
Yes, the 32A immunity is not available to any kind of promoter, may it be MSME or any other kind of company. It is not applicable to any promoter or their related party or even to those persons whose name is mentioned in the charge sheet.
So NCLAT should be reject the plan.
So the bank seems to be right. Now the option perhaps for the promoters would be to either make changes in the resolution plan and still continue with the plan, else just let the plan be rejected. That would be the
Okay. Thank you.
So we have some of the judgments where some questions must be coming in the minds of the our audience. So in fact, I also wanted to tell this Rajiv Chakrabarti judgment. Rajiv Chakrabarti was the IRP of IRA Infra Engineering Limited and versus Director of Enforcement. It is a judgment from Delhi High Court. It is dated 11th of November 2022, and the in this particular case, the application, the RP made an application. RP made an application before Delhi High Court. One, for the quashing of the provisional attachment orders from the Enforcement Directorate. Then declaration that the Enforcement Directorate does not have jurisdiction to attach properties under the PMLA once the CIRP is initiated. Once the CIRP initiated due to moratorium. So one, that this particular judgment was based on moratorium under section 14 of IBC. It was not argued based on section 32 capital A of the IBC. So that's a very big difference in this case. And therefore, it was argued before Delhi High Court that the properties may be released because of section 14, because of moratorium. Now, the facts in this case is that in April 2018, in fact, 74 bank accounts were attached by Enforcement Directorate, all belonging to IRA Infra Engineering Limited, and that was under section 102 of the Code of Criminal Procedure 1973. Then in the May 2018, the CIRP started, and after the CIRP in October 2019, Enforcement Directorate further attached 49 bank accounts. So therefore, the 2 provisional attachment orders were issued, and the RP in fact made an application saying this is a moratorium and the PMLA should be stayed. And then again it was said that the section 32 of the IBC extends protection to corporate debtor after a resolution plan is approved, barring any. But then in that time the resolution plan was not approved. So therefore, Delhi High Court held that the Delhi High Court said the moratorium under Section 14 of the IBC does not prevent the Enforcement Directorate from attaching the properties. Again, ED's action under PMLA are not aimed at debt recovery but are part of the penal action to confiscate properties derived from criminal activity. Hence, the moratorium does not apply. That was the judgment was dismissing. See, but when we are saying all this, there are in fact multiple judgments where some uh, uh, application before Supreme Court has actually been filed. In this particular case, one is the JSW Steel versus Enforcement Directorate. In this particular case, the JSW in fact acquired Bhushan Power and Steel Limited through an approved resolution plan, and Enforcement Directorate attached Bhushan Power's assets under the PMLA, citing offences committed by the previous management. Then JSW contends that Section 32A provides me the immunity, and then the Supreme Court decision is in fact anticipated in this case. Similarly, the Committee of Creditors of Bhushan Power and Steel versus Tish Kumar Gupta, this is also as per Section 32A. This is also pending with the Honorable Supreme Court. Another case, which is Bhushan Steel, which was acquired by Tata Steel and BSL. There also the ED is challenging the attachment. Even in the case of Nitin Jain, that case in the Enforcement Director has also gone to the Supreme Court, and because of one line written there that Section 32A, the ED could not attach assets of PSL after the approval of the resolution plan. In fact, the ED is challenging this. Even this Rajiv judgment, again, the other party has gone to the Supreme Court. And even in the case of Sterling SC judgment, Enforcement Directorate has gone to Honorable Supreme Court. So these are various judgments where the parties or Enforcement Directorate have gone to Honorable Supreme Court. So in the case of Nitin Jain versus PSL, in fact, the court actually held one part. One part was held by the court that Section 32 of the IBC should be the governing provision once the liquidation or resolution plan is approved, and ED action could not supersede this protection. So ED, in fact, filed an appeal before Honorable Supreme Court only because of this line written in this order, because ED is still trying that the Section 32A is not applicable to proceeds of crime. Then we also have this judgment from Delhi High Court in the case of Aryan Construction versus Punjab National Bank. This judgment is also latest, 5th August 2024. This judgment is from Delhi High Court, and this also has actually in the case of Bhushan Power and Steel. So this is again, I believe, will be tagged with the Supreme Court judgment. But in the case of Madras High Court, this Vasan Healthcare Private Limited versus India Infoline Finance Limited, this is a judgment from Madras High Court, and in this case, the court held that in this case the Madras High Court quashed the prosecution against Vasan Healthcare Private Limited, but clarified that Section 32A does not protect former directors who may still face liability. That is what was held by Madras High Court. And in the case of Welspun Steel Resources Private Limited versus Union of India, the High Court of Gujarat on 17th of February 2023, they also held, and the observations therefore in this particular case, the Honorable Gujarat High Court observed that Section 32A grants immunity to corporate debtors' asset post-resolution or liquidation, provided the sale followed due process. The assets purchased by Welspun through liquidation could not be treated as proceeds of crime since they were not directly tied to any criminal activity but were acquired in compliance with IBC provisions. Allowing attachment on such assets would undermine the IBC's objective of maximizing value in resolution and liquidation. The Gujarat High Court ruled that the attachment order by the ED violated Section 32 capital A, holding that assets purchased lawfully under liquidation could not be considered proceeds of crime. It directed the ED to release the attached assets, reinforcing that the Section 32 capital A shield assets sold in compliance with IBC from Enforcement Directorate. This is actually very, very important that this particular judgment of Wellspun also very clearly says that Section 32A is also applicable in liquidation cases. Further, in the High Court of Kolkata, Gauri Prasad Goenka versus State Bank of India, it is the judgment dated 20th of March 2024, and it finally says that this was an application, and in fact somebody was trying to take the benefit of 32A, and the court examined Section 32A carefully and noting that the provision offers immunity to the corporate debtor and its assets, protecting new management from liabilities associated with prior misdeeds. However, this immunity does not extend to directors or officers responsible for past willful defaults. The court underscores that Section 32A's immunity is limited to facilitating fresh management and operations post-resolution and does not absolve directors for prior misconduct, including willful defaults. So this is a question which one of my friends was asking, that willful default is not protected. The promoters can be proceeded against. There is another judgment which says that even Section 132 of Negotiable Instrument Act, that also is can be proceeded against. On that particular, when the promoters are concerned, the promoters are not protected under Section 32A, but the company is protected for all kinds of prosecution in the past. So these are various judgments. Ankit, I think we can talk about any other question, or we can conclude. In fact,
only one question which is pending, which is from Ravi Shankar, Mr. Ravi Shankar Devakonda. He says that if the CD is marked as a willful defaulter, there is a difficulty for getting resolution plans for that CD. Have you encountered anything like that?
There is no difficulty even if the CD is like branded or declared as a willful defaulter. The CD actually will get all kind of immunity under Section 32A when the resolution plan is approved and the resolution plan is not submitted by the promoters or erstwhile management. Then all kinds of prosecution, willful defaults, Section 138, all will be shall have any adverse impact on the resolution applicant.
Right.
Sir, the problem what was happening is that as a matter of routine, the banks are declaring the corporate debtor and the directors as willful defaulters. So when we went to the bank and said that, sir, if you're declaring the company as a willful defaulter, we are not getting any REAs.
But that's not true. The RA very well knows, all the consultants in this country, they very well know that this willful default, when this management will be changed and the resolution plan will be approved, the willful default will automatically have no adverse impact on the company, because it's
when the NCLT order is approving the plan, they are not giving a direction saying that the willful default tax should be removed, because they say that you go to RBI and do the banking thing, kind of a thing.
No, I think even the NCLT says, because NCLT presumes that they don't have any power on RBI. So once the resolution plan is approved, and simple application can be made to RBI for removing the name of the company from willful defaulters, and that would be done. And trust me, that will be done.
Okay, sir. Right.
So thank you everyone for the very, very interactive session that we had today. We were able to take up a lot of questions, and the subject was such that it brought a lot of queries as well. So thank you everyone, and we will see you again next week.
Thank you very much. Thanks a lot. This is our way of learning. Thanks a lot.